good afternoon, everyone. Welcome to our third round of sessions. Joining me now, is Nadia Zaman. She is an employment lawyer at Rudner Law. Nadia is passionate about employment law and enjoys representing both employers and employees in all aspects of the employment relationship. In particular, she enjoys advocating on behalf of employees and positively impacting their working lives, as well as providing proactive, strategic advice to employers to ensure they are complying with the law and minimizing liability. She regularly speaks and writes about employment law, and she is committed to educating others about their rights and obligations so they are able to make informed decisions. Thank you, Nadia, for presenting at the event today. Good luck on your presentation. And I'll be here just helping out with anything in terms of moderation. So if you have any questions or if there's any issues, you can just feel free to post it in the chat and I can come back on.
Thank you, Sandra, for the wonderful introduction. So hello, everyone. Welcome to this session on the strategic use of contracts and policies, what employers need to know. As Sandra said, my name's Nadia Zaman, and I'm an employment lawyer at Rudner Law. We assist both employers and employees in all aspects of the employment relationship, starting from hiring to dismissals and everything in between. Our firm is quite big on strategic HR. We also have an HR checkup for employers of all sizes, where we review key documents such as contracts and explain how we can help. You can download the HR checkup directly from our website, or you can email me at nadia@rudnerlaw.ca and I will send it to you. Now, the reason why all of this is particularly important is because of the pandemic. The last 1.5 years have reinforced the need to be strategic. For example, most employers didn't realize how temporary layoff clauses could have helped them be more strategic. And we Hi, everyone, once again. So I'm not sure what happened over there, but I'm going to share my screen once again. So what I was saying is that the last 1.5 years have reinforced the need to be strategic. For example, most employers didn't realize how temporary layoff clauses could have helped them be more strategic. And we have several longstanding employer clients who were thankful because we had advised them to have such clauses in their contracts. So in light of the pandemic, they could temporarily lay off employees without worrying about a lawsuit. Employers have also been exposed to substantial dismissal costs in light of the pandemic and realized that they need enforceable termination clauses to save on dismissal costs. We've also received several inquiries relating to remote work arrangements in light of the pandemic. And last but not the least, health and safety has been a key consideration since the pandemic. By strategically using contracts and policies, employers can not only increase their flexibility, but also control their costs. Now, before we move on, I'll point out a disclaimer. So this presentation is not intended to provide legal advice. It's provided for informational purposes only, and it is current as of today's date. If you would like legal advice, please feel free to contact us, and we'd be happy to assist you. Now, it's important to keep in mind that every employment relationship is governed by the complex and ever-changing set of rules and obligations that make up Canadian employment law. We have the employment standards legislation that sets out the minimum requirements employers must comply with. We also have human rights legislation, occupational health and safety legislation, privacy, labor laws, and the common law. The common law is essentially judge-made law. These are decisions that are made over time based on various legal principles and the particular facts of each individual case. Now, I'm hoping that I can get some participation from you here, and obviously there's going to be no judgment whatsoever. I'm going to run some polls. Hopefully it's going to work. And all you have to indicate is whether or not the statement is true or false. So for the sake of time here, what I'm going to do is I'm just going to say probation in the question mark, but obviously you can see what in the question in the box for the question, but you will be able to answer whether or not it's true or false. So I'm just going to start this. So if you can indicate whether or not you think the statement, every employee has a probation period during which they can be dismissed without notice or cause, if you can indicate whether or not that's true or false, that would be great. So I'm going to give a little bit more time. Okay. So let's see the results. So actually in the poll, only one person voted, but in the chat, there's two people. One person said true, one person said false. And then in the poll, the results are showing that, the individual voted true. So this statement is actually false, although it is often assumed to be true, as we can see. A probation period is not automatic. An employer needs to include a probationary clause in the contract specifically stating that it has the right to dismiss the employee without notice or cause during the probationary period. Otherwise, an employee will be entitled to reasonable notice of termination pursuant to the common law. Now, let's go on to the second statement. Now, if you can indicate it in the poll, that would be great. So I'm just setting it up right now, and I'll let you know as soon as it's created. So all you have to indicate is whether or not it's true or false. So the statement is severance is 1 month per year of service. And you have to indicate whether or not it's true or false. So I'll just give a little bit more time here and then show the results. Okay, so we have one vote so far here. It's false, and that is correct. It's a common assumption, though, that an employee only needs to be provided with their minimum entitlements, regardless of what the contract says, or that it's always 1 month per year of service, regardless of what the contract says. And another common mistake is employers often require employees to sign a release in exchange for their minimum statutory entitlements. Employees are entitled to minimum statutory entitlements regardless of whether or not they sign a release. And making that a condition can expose employers to additional damages for bad faith conduct in the manner of dismissal. Now, let's move on to the third statement. And I think people are shy here. So what I'm going to do is I'm not going to run the poll, and we're just going to discuss it. So the third statement is employees can agree to average their hours over several weeks instead of accruing overtime weekly. And this statement is true. However, the agreement has to be worded properly, and there are certain limitations. But often employers just assume that that's not possible, and they can't have employees agree to that. So in that manner, employers often limit themselves, even though they can have more flexibility and they can exercise certain rights. They often assume that they don't have such rights and don't implement those contracts. Now, the last statement, it's also relating to overtime. It says salaried employees don't get overtime pay. And this is a fairly common myth. The statement is false. If the employee is salaried, they may still be entitled to overtime pay. And employers can be exposed to substantial liability for not paying overtime pay to employees when they are entitled to it. So this just goes to show, these are certain statements that are often believed to be true. I mean, the third one is true, but the rest are false, but often assumed to be true. So it just goes to show that a lot of the times, employers are running their businesses without actually taking the time to strategically think about how they can maximize their flexibility. Now, I cannot stress this enough. The single best thing you can do is to have enforceable employment agreements in place. Every employee has a contract of employment. If you, as an employer, don't set the terms, then many employee friendly terms will be implied into the contract. And the most common mistake employers make is to have new employees sign the contract after they have already started working. These contracts are not enforceable because they lack consideration. Before the employee starts the job, the offer itself can be consideration for signing the contract. But if the details have been finalized and the employee's already started working, what are you giving them in exchange for signing the contract? Unless you provide fresh consideration, that is something of value in exchange for signing the contract will not be enforceable. So the fresh consideration might be a signing bonus, or it could be some other greater benefit. But at the end of the day, you can use the contract strategically. And there's two aspects to this strategic approach. The first is strong enforceable wording, and the second is proper implementation. Both are very important to ensuring that you can actually rely on the contract. And we'll also talk about, how you can implement such enforceable contracts for existing employees, because a lot of employers don't have enforceable agreements in place for their existing employees. So they might be implementing enforceable contracts for the new employees, while the existing employees either don't have written contracts in place or have unenforceable contracts in place, in which case the employer would be exposed to substantial liability. So, why use contracts and policies? As noted earlier, you can increase your flexibility as an employer and control costs. In addition, you can increase certainty, protect your organization's interests, restrict an employee's post-employment conduct, and govern your workplace. Now, there's no universal employment agreement that will work in every situation. While it's helpful to develop a template or perhaps multiple templates to differentiate between levels of staff, it should be carefully customized each time for the employee in question. What looks like boilerplate often isn't, and the fine details in the wording can become key pieces of the employment relationship. So often we see employment contracts issued with the wrong name or the wrong employer or the wrong salary. So you should make sure to review every word carefully and ensure that the contract is right for the particular employee. There may also be things to consider in light of the pandemic, such as temporary layoffs and remote work. The main thing is that you just want to make sure you customize the employment agreement to your workplace as well as to the particular role in question. Now, there are two issues to consider with respect to the enforceability of the contract. The first is whether the contract is enforceable, and the second is whether the clause is enforceable. As I mentioned, all employees have a contract, but most are just verbal. And what the contract includes are the items discussed verbally or in writing, plus many implied terms that are for the protection of the employee. So whatever you're not discussing or including, it may be implied in the employee's favor if you don't say otherwise. The statute, and in most cases, it's going to be the Ontario Employment Standards Act. The statute sets out various terms of employment, including minimum wage unless there's a verbal agreement or written agreement for higher pay, hours of work, overtime, vacation, leaves, etc. And although you can, set the terms and conditions in the contract can go below the statute. If it does, it won't be enforceable. So the statute sets out the minimum requirements. And if you don't provide those minimum requirements or anything beyond that, then it's not going to be enforceable. The common law adds many more terms, including reasonable notice of dismissal, unless the presumption of reasonable notice is rebutted by an enforceable termination clause. So if you don't have a termination clause in the contract, let's say, then it's going to be assumed that reasonable notice under the common law is going to be applicable. So you can limit an employee's entitlements upon termination under the contract, but you have to make sure that the contract is enforceable and the termination clause is enforceable as well. Now, in order to ensure the contract will be enforceable, employers should avoid verbal offers of employment and hiring before the employee signs the contract. If there are any changes, then fresh consideration will need to be provided. In addition, you should review contracts regularly to ensure that they reflect the current state of the law. The law is constantly changing. And, during the pandemic itself, there's been so many changes with respect to employment law that it really kept us employment lawyers on our toes. But the more important thing is with respect to employers and business owners, it was very difficult to make sure that you're in compliance with the law at each stage of the way. And it's not an excuse to just say, I didn't know what the law was. In most cases, it's going to be expected that, you are complying with the law. So it is important to make sure that you're reviewing them regularly and ensuring that it's reflecting the current state of the law. And lastly, you shouldn't just use a contract off the internet. You should seek legal advice and make sure that the contract is customized, as I said, to your workplace and the particular role. And even if, a lawyer provides you with a contract, you shouldn't just use it as is, as a template for every single employee. You should read the contract and think about whether or not you understand what it means, what you can and cannot do, and whether or not it addresses all the issues. And even though the template can be used, for different types of employees, you want to make sure that you really customize it for that particular employee. Now, some of these best practices I've already mentioned, but I think it's important. So in short, the best practice is to ensure that there's no verbal offer, that there's no offer letter separate from the employment contract. You want to ensure that the employee is not hired until they sign the contract and meet any conditions of employment. You want to make sure that the contract is signed before the employee start date. You want to avoid any confirmation until they have signed. So any confirmation that they have, joined the company already or anything along those lines. And as I said, you want to review and update contracts regularly based on legal advice and provide consideration or notice for any changes. Now, you might be wondering, what about your current staff? There are two ways you can implement enforceable contracts for current staff. You can either provide consideration in exchange for signing the new contract, such as a signing bonus or a raise, or you can provide notice of the change. It's important to keep in mind that the test is not whether the employee signs the contract, but whether the contract will be enforceable if and when it is challenged. Now, termination clauses are one of the most hotly contested topics in employment law, but it is very important to have proper termination clauses in place because they can save substantial dismissal costs. For example, for a 65-year-old office manager with 27 years of service, you can have a written agreement that limits their entitlement to 8 weeks of pay upon termination. Versus if there's no written agreement, then you could be exposed to paying them 24 months of pay. That's a huge difference between, what could happen if you have proper agreements in place versus not. You can avoid the uncertainty of reasonable notice under the common law by having enforceable contracts in place, and you can reduce your dismissal costs and your obligations. Of course, as I said earlier, the contract should be tailored to the employee's role, but don't assume you have to provide 1 month per year of service or that you cannot contract out of the common law. You just need to have the proper agreements in place to do that. Now, how do you make the termination clause enforceable? This is tricky and they are routinely challenged, so you want to make sure you get legal advice from an employment lawyer. The termination clause must clearly displace the common law. It cannot provide less than the statutory minimums or have the potential to provide less than the statutory minimums. So this gets tricky because even if an employer provides the employee with the minimum under the statute or more than the minimum under the statute, if the termination clause itself potentially breaches the Employment Standards Act, it's not going to be enforceable, and the employer is going to be exposed to providing the employee with reasonable notice or pay in lieu of notice under the common law. We also have a recent case which shows that even if the termination is without cause, the termination with cause section of the contract must be valid. Otherwise, it will invalidate the entire clause and the employee will be entitled to reasonable notice under the common law. You can also use severability and saving clauses, but they're not always enough to save the clause. Now, with respect to restrictive covenants, by default, employees can resign, go to the competition, and solicit customers. Restrictive covenants can address the post-employment conduct, but you have to word them very carefully, and it has to be limited to the least extent possible. Because if you ask for too much, the clause could be overturned in its entirety instead of being read down. So if you have a non-solicitation clause for, let's say, a 2-year period, and the court thinks that, that's excessive and is not necessary to protect your business interests, they're not going to say, okay, you know what, 2 years is too long, but 1 year would be sufficient, and read it down to 1 year. It would just be struck out in its entirety. Now, there's also, the duty of confidentiality that applies to all employees. Fiduciary employees have greater duties. And with respect to the restrictive covenants, you want to make sure that the terms are reasonable, including the length of time, what the nature of or scope of the restrictions are. And if you have a non-solicitation clause, for example, you don't want to restrict the employee from accepting business. So you can restrict an employee from soliciting business as long as, the scope is narrow enough. But you cannot say you can't accept business from our customers either, because that's going to be seen as extending too far and is going to invalidate the non-solicitation clause. The other question to think about is, even if there's a breach, what are the damages, right? So that's something that you would want to quantify as well. Like, is there an actual loss to the business or not? So I'm going to skip over a little bit just for the sake of time. So with respect to one of the common mistakes that employers make, there is a distinction, an important distinction between employees versus independent contractors. But often what ends up happening is that an employee will be treated as an independent contractor, and often an employer thinks that just because an employee is labeled as an independent contractor and the employee is okay with that label, that they can be treated as an independent contractor. But that's not entirely the case. It's not just the terms of the contract that's going to govern whether an individual is an employee or an independent contractor. And just because you label someone a contractor does not really make it true. There are several factors that courts look at, with control being central. And ultimately, the question you're asking is, are they part of the organization or are they in business for themselves? There are also penalties for employee misclassification as contractor under the Employment Standards Act. So you could be exposed to liability for misclassification, as well as potential tax consequences for failing to make employment-related deductions. Now, I'm skipping over to this section. So with respect to policies, a lot of employers don't recognize that some policies are legally required. And there are others that will give you additional rights but may not be required by law. So there is the distinction that needs to be made between policies that are legally required. Often it's based on what's the nature of the organization, what's the size of the organization, and different requirements apply to different sizes. So a small employer versus a medium-sized employer versus a large employer. And what you want to do is make sure that you are complying with the law. First and foremost. So that would be the first step of the way, to make sure that you at least have the legally required policies in place. The second thing would be to consider, okay, what are the policies that are recommended? And obviously it's going to depend on the nature of your workplace and what's, really important. If you have an issue, for example, in your workplace with respect to attendance and absences, employees regularly missing their shifts or not arriving on time or providing very short notice of their absence, then you probably will be benefiting from an attendance and absences policy, for example. But that's not something that's required by law, but it is potentially going to help your organization a lot. If you don't have rules, then you can't really discipline those employees for breaking them, right? Because the rules don't really exist, or you can't really show that that rule existed in your workplace. And the other thing to consider is what else is relevant to your workplace, because you want to make sure that you are customizing the policies based on what's needed within your organization, and every organization will have different types of needs. So we're talking about, the types of policies and, what's required, what's recommended, but that's only one step of the process, like creating the policies, but it's not a one-step process. And you also have to implement them properly. These are the criteria on the slide. These are the criteria that we set out whenever we're speaking with our employer clients about implementing new policies. And the same rules apply when you're making changes to your existing policies. Because at the end of the day, a policy is not going to be very useful if no one knows that it exists or which version to follow. So you want to make sure your employees are aware that these changes are being implemented, prepare them ahead of time, make sure that everyone is aware of their rights, obligations, and duties, and provide them with training that is appropriate to their duties and responsibilities. So for example, a manager will likely need more detailed training on the disciplinary policy if they have, reporting relationships than someone who does not have direct reports. And last but not the least, procedures can save you. It's not enough to have policies. You also have to ensure that they're implemented and followed. And often that means that you have these procedures. So for example, you might have a procedure with respect to the accommodation process or harassment complaints. Who are they making the complaints to? What's the next step after that, et cetera, et cetera. You want to make sure that everyone understands the process as well as their rights and obligations. Now we have a minute for any questions. If anyone has any questions, you can either put it in the Q&A box Or, if I'm not able to address it now, you can also send me an email or connect with me on LinkedIn, and I would be happy to speak with you. So I don't see any questions here. So I'll just say that, I thank you all for attending this presentation. And as I mentioned, you can feel free to contact us if we can be of any assistance. You can also follow our blog at rudnerlaw.ca/blog. You can also check us out on social media, various platforms. And if you want to join our newsletter, you can send us an email to sign up for our newsletter to get, recent employment law updates from time to time. And, if you have any questions or concerns, you can reach out to us as well. So thank you, everyone, once again, and I hope you have a great rest of the week.